Well, good evening, everyone, and welcome back to CCI Huronia's Intro to Condo course. Thank you so much for joining us tonight. If this is your first time with us, well, welcome. We're so glad to have you here. And if you've joined us on one of our many webinars that we've been doing over the last 3 years, thank you for coming back and spending some more time with us. My name is Sonja Hodis. I'm one of the many directors at CCI Huronia, and I'm a condo lawyer as well as your moderator today. And today's webinar, we are going to be covering condominium basics. This is a course that we put on every year, and it's really intended for owners, directors, tenants, potential owners, potential directors, property managers, anyone that works in the condominium industry, basically anyone that wants to just get some information about what condos are all about, how they operate. And today's course is really just going to give you that really good foundation. However, after having today's course and learning a little bit about what condos are all about, if you feel the need to get some more intensive training on what condos are and how they operate, please join us on April 22nd and 23rd as we do our 2-day intensive director's course. Now, although this is a director's course, you don't have to be a director to attend. But it is a good course if you are a member of the board of directors. We're going to be covering sort of all the issues from A to Z that directors have to deal with. If you want to find out details about the director's course, you can go to our website, ccihuronia.com, register online, also find out about the details of the agenda for the 2 days. So we hope to see you there. Before we continue, I want to take this opportunity to thank our sponsors. As I've stated before in many of our webinars, without the support of our sponsors, we're not able to bring you these events free of charge. So thank you to Aaliyah Associates Condominium Lawyers, Common Ground Condo Law, McIntosh Perry, Brown & Beatty, and Registon Building Restoration. If you want to find out any more information about our sponsors, just go to our website, ccihuronia.com. On our landing page, you'll see their logo. You can click on their logo. It'll take you directly to their website where you can find out about what services they provide and their contact information. Also, you can just go back to the event page for today's event, and their logos are there as well. That's where you'll also find a recording of today's webinar, which will be posted in about 7 to 10 days. So thank you again to our sponsors. I also want to take this opportunity to thank our speakers tonight. We've got a variety of speakers with us who are all professionals in the condominium industry and come from different backgrounds. But one thing that they all have in common is they're all part of the CCI Huronia Board of Directors. So thank you to all of our speakers tonight. If you want to find out more information about our Board of Directors and the speakers that you're going to hear from, again, go back to our website, ccihuronia.com, go into the About tab and just click on Board of Directors, and you'll find information about all of our speakers there. Also, while you're on the website, don't forget to check out our Condo Buzz newsletter, which is available there. And you can follow us on Facebook and also follow us on LinkedIn. And if you're watching our recording of one of our past webinars, which are also available on our website under the Resource Content tab, make sure that you go onto our YouTube channel and subscribe to our channel, as well as like the video, make a comment, and share it with others who you think may find it useful. Now, in terms of how we're going to do the webinar today, we are going to be taking questions. We actually have 2 dedicated question periods throughout the webinar. And this is a great opportunity to ask your questions about condos. No question is a stupid question. We've got lots of people here who can help answer those questions. And this is one of the things that really distinguishes this course from the mandatory director training course that the CAO puts on, because you actually get to ask questions and have them answered. So if you have a question, put them in the chat box or put it in the Q&A box, and we'll get to those questions throughout tonight. And just a reminder to everyone that the information that you are hearing tonight is general information, and it may not apply to your specific fact situation. So if you're a condo director and you want to use the protection of Section 37 of the Condominium Act, you need to get an opinion about your specific fact situation from your own professional. The webinar tonight is not intended to provide you with opinions that protect you under Section 37 of the Act. In addition, there are people who are going to be watching this webinar at a later date. So the information in this webinar is current as of February 1st, 2023. As we know, things change rapidly, and the information that's provided today may not be relevant at a future date. So be sure to check with your professionals to make sure that the information that you've received is still relevant and applicable. And also, if you're watching this webinar from outside of Ontario, just be aware that any reference to the Condominium Act or other legislation is reference to Ontario legislation. So before we get started, I am going to ask Jeff Struing, who is our CCI Huronia president, to say a few words. Jeff?
Thanks, Sonja, and good evening, everyone, and thank you for joining us this evening for our Intro to Condos course. It's great to have so many of you joining us tonight. I also want to thank Sonja and our Education and Events Committee for all the hard work they do to organize these events and our very popular webinars, as well as a thank you to our speakers this evening and our sponsors. CCI Huronia is always working hard behind the scenes to develop meaningful and timely webinars for our members. If you have any topics you would like to see covered in a future webinar, please send us an email at admin@ccihuronia.com. We have many new faces here this evening, so I'll provide a brief summary of what CCI does for the condominium sector. We are celebrating 40 years, and we lead the condominium industry by providing education, information, awareness, and access to expertise by and for our members. We are the voice of condominiums in Canada. CCI operates primarily through chapters across the country. The Huronia chapter is one of 17 nationally, all working together coast to coast. We are your condo connection. As a nonprofit, we rely on the support of our members and our sponsors to be able to continue delivering great educational events. If your condominium is not already a member, please have a look at the benefits of being a member on our website, ccihuronia.com. And if you are already a member, we thank you. And please encourage any condominiums you know to consider membership. Becoming a member has never been easier with the ability to sign up and pay right on our website now. Members enjoy access to the Resource Center on our website, our Condo Buzz newsletters, and discounts on events, educational courses, and seminars. The Resource Center includes videos of our past webinars, past newsletters, as well as relevant articles from across the country and access to the National Resource Center. And lastly, please don't forget to like us on Facebook. And with that, I'll turn things back over to you, Sonja.
Okay, thanks, Jeff. So let's get started with our first topic tonight, and that is, what is a condo? And joining us tonight to discuss that is Mina Tesseris, who is an engineer and a member of our CCI Huronia Board of Directors. Mina?
Thanks, Sonja, and thanks everyone for being here tonight. I'm just going to cover off the topic of what is a condo. Seems like a simple question, but when you dig down deep into it, it's a little more complicated than just a building, which people are commonly consider a condominium to be. It's actually not a style of building, but a condominium is a type of property ownership. In the condominium, you'll have units, common elements, exclusive use common elements, assets, and shared facilities. The owners within a condominium own their unit, as well as an interest in the common elements and assets. So the unit, what is a unit, and why is it important to know what a unit is? The simplest answer to that is that if you know what a unit is, then by default, you will also know what the common elements are. And I'll explain that in further detail. Within a condominium, there's what's called a declaration and description. And it's basically, the declaration is basically the constitution of the condominium. The declaration will set out what's called the unit boundaries, and those are typically found in Schedule C of the declaration. So the declaration sets out the boundaries of the unit, and it'll have language such as the unit is vertically bounded by a line that is at the face of the exterior wall or interior plane of the windows, or language to that effect. And it's horizontally bounded by the top surface of the concrete floor and the underside of the concrete ceiling. And so those boundaries of the unit will tell you what is within the actual unit. And so again, by default, common element is everything outside of the unit. And so the declaration doesn't actually lay out what is common element. The declaration lays out what is a unit, and by default, the common elements are everything outside of the boundaries of the unit. We also, in a condominium, will have what's called exclusive use common elements, and those are common elements that are owned by the unit owners as a group. So the unit owners each have a percentage share of those common elements, but they are assigned for the exclusive use of one or more specific units. So an example of an exclusive use common element would be a balcony or a terrace, or in the case of a building with underground parking, an underground parking spot. Those are all examples of exclusive use common elements. They are for the exclusive use of the assigned unit owner. Assets are unlike common elements. Assets are similar, are like not a fixture, but a movable type of asset, such as a refrigerator, a couch in a recreation room, or a meeting table and chairs within a meeting room. They're not fixed as you would know a window or a roof or some other type of component of the building. And finally, we have shared facilities, which are typically not covered in a declaration. Shared facilities are typically defined within what's called a shared facilities agreement. And shared facilities are just that. They're facilities that are shared with other condominium corporations. And there's usually an agreement between condominium corporations that set out the rights and obligations of each condominium with regard to those shared facilities. An example of a shared facility would be a recreation center, perhaps a docking facilities if you're on a waterfront condominium, those sorts of things. So that, in a nutshell, is what is termed to be what the definition of a condominium and what a condominium consists of. In the diagram or in the slide that you see before you in the top right, you'll see what looks like a boundary survey, and that is actually what we call a description. And a description is an illustration of the declaration. And the description shows the boundaries of the unit, and once again, everything outside of the boundaries of the unit shown in the description are common elements. That's it for me, Sonja. I'll pass it back to you.
Thanks, Mina. And, those are very important terms that Mina started us off with, and you'll be hearing some of our other speakers talking about units and common elements and shared facilities and exclusive use common elements. So those are very key words to make sure that you have an understanding of. So thanks, Mina, for explaining those to us. So we're now going to move to our next speaker, who is Ashley Lamb, and she is our resident condo real estate guru and the editor of our Condo Buzz newsletter. And Ashley, you're going to talk about the different types of condos. So if somebody thinks that there's just one condo in Ontario, they're going to be in for a surprise, because we actually have a few different types of condos. So Ashley, can you explain that for us?
Yes, thank you, Sonja. So I'm going to start off with a standard condominium. A standard condominium is created when a declaration and description are registered at the land registry office. It is a mix of separate units, owned units, and common elements. Now, there's also phased condominiums, And those normally happen when a large condo development is being built. There is the ability to add units and or common elements that are built onto the original condominium. Once all phases are completed, the complex operates as a standard condominium. So they kind of go hand in hand together. Now, with a common element condominium, there are actually no units. Examples of common elements are roadways, sewage systems, recreational facilities such as ski hills or golf courses. The benefit of using the common elements and the corresponding responsibility to pay for the cost of the operating of the common elements are actually attached to the parcels of tied land. Now, there's also a vacant land condominium. Those are where no buildings or structures are on the land at the time the declaration and description are registered. This actually allows a developer to build the individual dwelling when the vacant land units are sold. Vacant land unit condominiums cannot be leasehold condominiums, that's the next one, or common element condominiums, but they can be a phased condo. Lastly, a leasehold condominium is a condominium developed on land that is not actually owned by the condominium or its owners, but is leased from an owner agreeable to a ground lease. They are actually one of the more affordable condominium types, and that's because the land cost component is amortized over a 40 to 99-year lease. So there's really about 4, 5 if you end up dividing phased condos and standard condominiums.
Thanks, Ashley. And can you tell us, just from your experience in our area here, Barrie and surrounding area, what do we tend to see in terms of the type of condominium?
Normally a standard condominium or a phased condominium, depending on how large the project is. But there are some common element condos too.
All right, thanks. Okay, so moving on to our next topic, we have Ashley number 2, Ashley Winberg, who is a condominium lawyer with Aaliyah Associates and on our board of directors. And Ashley is going to talk about director responsibilities and governance. Ashley?
Hi, everyone. So Section 17 of the Act sets out that the objects and duties of the corporation are to manage the property and assets on behalf of all of the owners, and that the corporation has an obligation to take reasonable steps, to ensure that owners and occupants comply with the Act, as well as the declaration, bylaw, and rules of the corporation. So that's what the corporation's objects and duties are. Now, Section 27 of the Act states that the board is to manage the affairs of the corporation. So Section 27 through 241 of the Act sets the minimum standards of operation to be met by directors and officers of a condominium corporation. If you refer to each of your condominium corporation's general operating bylaws, there may be more specific standards or qualifications that must be met by the directors in your individual condo's general operating bylaw. Now, the vast majority of condominium boards' decisions are not subject to owner approval, given that it's being run by an elected board. However, there are some decisions that do require owner approval. Specifically, if you look at Section 97 of the Act, when it comes to making any changes to the assets or the common elements that meet a certain threshold, or if the corporation needs to borrow money to finance a project that requires a borrowing bylaw that would have to be approved by owners. Section 27 of the Act also states that every condominium corporation needs to have at least 3 individuals acting as directors. Each of your condominiums in the bylaws may stipulate a greater number of directors, but at a minimum it is 3. And in order to be a director at a minimum, one has to be at least, they cannot be under the age of 18. They cannot be mentally incompetent, and they cannot be an undischarged bankrupt. However, as I mentioned, your individual condos bylaws may provide a couple more qualifications that need to be met. Section 37 of the Act stipulates that every director and officer of a corporation has to exercise the powers and duties of their office honestly and in good faith. So acting honestly and in good faith means taking an honest belief in the actions that you're undertaking in your role as a director, abstaining from malice, and not trying to take advantage of your position or any other owners. Acting in the best interest of your condominium corporation involves a fiduciary duty. And so a fiduciary is someone who has agreed to undertake or act on the behalf of another in a manner that affects the legal interests of that other individual or legal person. So a director of a condo doesn't owe a fiduciary duty to individual unit owners, so not your neighbor, but to the condominium as a whole. And this is something that's often difficult for many board members to deal with, given that they're also members of their condominium communities. So a director has to, acting as a fiduciary, uphold decisions of the board, even if they do personally disagree with them, and if they may have voted against the decision potentially. Now, this can be challenging, as I mentioned, but that is the role of a director as a fiduciary. Another thing that Section 37 stipulates is that directors have to exercise the care, diligence, and skill of a reasonably prudent person in comparable circumstances. So this is the same standard that's stipulated in the Ontario Business Corporations Act, and this is an objective standard. So the degree of care that a condominium director is required to exercise based upon this requirement, the Section 37, would mean that their conduct would be compared to another condominium director in similar circumstance in another case, perhaps. So as to ensure that directors, or to assist directors with complying with this fiduciary duty and various obligations, Section 37 of the Act also stipulates that any decision taken by a director, if they rely and act in accordance with the opinion of a lawyer, engineer, auditor, or other individual whose profession and experience lends credibility to their opinion, the director will not be held personally liable if they rely upon that decision. So if your condominium board gets an opinion letter in writing, has been writing, opinion letter from a lawyer on the lawyer's letterhead that advises the corp board to act in a particular manner in the best interest of the corporation, and the board decides not to follow that advice, and potentially that decision exposes your condominium corporation to liability or risk, then the individual directors who voted against that advice could be held personally liable. So in order to exercise the duty and standard of care required of directors, it's advised that directors make informed decisions, come prepared when you attend your board meetings, ensure that your board meetings are organized and as frequent as necessary, and take proactive measures to ensure that any existing problems are rectified before they become larger issues, and to really seek the advice of professionals and to follow any advice provided. And with respect to making decisions, I just wanted to let you draw your attention to Section 32 of the Condominium Act, because a number, just given especially our situation now with COVID, a lot of boards, make decisions via email correspondence. And Section 32 provides that the board shall not transact business except at a meeting of directors at which quorum of the board is present. Now, as you all know, electronic meetings are now permitted based upon the current status of the act and the regulations, but transacting business decisions over an email consensus, that is not sufficient. So any email decisions that are made by our board would have to be ratified by the board at the next scheduled board meeting. And in terms of board meetings, the Act, if you refer to your general operating bylaw, it will state general guidelines that your corporation has to follow when calling the meeting, the quorum that has to be met, and so forth. And I'll stop there because I don't know if I have that much time left.
I think you've got one more slide there about good governance.
Okay.
If you've got some time, if you want to go over that.
All right. Sorry. So as I mentioned before, good governance essentially is just relying on the advice professional, seeking it out, being proactive, being organized, reviewing all of your financial statements, the meeting package provided to you in advance, being familiar with your condominiums documents. And I don't think it's up there, but a lot of owners rely on transparency. So good communication is key, especially in the eyes of owners.
Thanks, Ashley. That was a lot to cover. But if anybody has any questions about anything that Ashley talked about so far, or any of our other speakers have talked about, don't forget, you can put your questions in the chat, and we're coming up to a question period shortly, or you can just get them ready to ask them live when we get to that question period. So thanks, Ashley, for all of that. We're now going to turn over to our next section, which is condominium documents. And I'm going to talk about this section. And at the end of the day, condominiums are basically created through statute, which on the slide here, you see reference to the Act, and that means the Condominium Act. But they're also structured based on a variety of different documents. And these documents are really important that you understand them. And it doesn't matter whether you are purchasing a condo, whether you actually own a condo right now, whether you're on the board of directors, if you're a property manager, or you're a service provider working with condos, you need to understand these key documents, what they are. And then every condo has their own set of these documents. There's not a standardized document that every single condo uses. So every condo is unique, and you've got to look at the specific documents for that specific condo. So I'm going to talk about these documents in more detail, but one thing to remember is when we talk about these documents, there is a hierarchy to these documents. So at the very, very top, we have the Condominium Act. And in fact, on top of the Condominium Act and the rest of these documents, we also have the Human Rights Code. But I'm not going to get into a lot of detail about that because Ashley is going to talk about that at the end of the webinar. Under the Act, in terms of the hierarchy, the next document that's important is the Declaration. And we talk about the Declaration a lot of times in terms of it being the Constitution for your condo. And then under the Declaration, we have the bylaws. Under the bylaws, we have the rules, and under the rules, we have policy. So the hierarchy goes from the Act down to policies. The Act is paramount over the rest of these documents. As you go down, it gets harder. It gets easier to make changes. The higher you are up on the hierarchy, on the pyramid, it's harder to make changes to those documents. And the Act itself sets out how you change these documents. So let's start with the Declaration. They're sometimes referred to the Articles of Incorporation. A lot of times I like to just refer to them as the Constitution, because in terms of the documents that are specific for your condo, this document, the Declaration, carries the most weight. And it has a variety of different types of information within it. It talks about the boundaries of the unit, and Mina kind of touched on that. It'll give you the vertical and horizontal boundaries of the unit so that you know what the unit consists of. And as Mina said, anything that is not within the unit is by definition a common element. Very importantly, the document also sets out a schedule that assigns percentages to each unit. And this is your percentage of ownership, but it's also the percentage of the budget that your unit has to pay. And that's how we make up your common expense fees that you pay every month. It talks about what you can use your unit for and what you can't use your unit for. So there may be some restrictions or permissions given in the Declaration. And that's why it's really important that you understand what your specific declaration says because it will give you that kind of information. A lot of times when I get calls from people and they ask a question, the first thing I tell them is read your documents, because you'll probably find the answer in the documents themselves. Now, the declaration can be changed. It's not easy to change a declaration. It can be changed on the consent of the owners, and depending on what you want to change in the declaration, you will need to get 80 or 90% of owners to actually sign off, physically sign off to the change. And anybody that's been involved in trying to change a declaration, a lot of the property managers on the call tonight will know how difficult it is to get 80 or 90% of owners to actually sign a document consenting to a change. Alternatively, you can get a court order, but it's not easy to get a court order to change the declaration. So declaration, it's your constitution. It's not easy to change. It's going to tell you the boundaries of your unit. It's going to tell you the percentages that are assigned to each unit, and it's going to tell you some of the things you can and can't do. The next document are the bylaws. Now, the bylaws, Ashley referred to one bylaw specifically, and every condo is going to have one of these. And this is your sort of general operating bylaw. And that will tell you how the condo can operate with respect to notice requirements and how meetings are held, who can be a director. For a lot of condos, this will be your bylaw number 1, unless it's been amended. It can be changed. Bylaws can be changed, and they're a lot easier to change than the declaration. You just need more than 50% of owners to approve the change. So that's a little bit easier. And now with the changes in the legislation, there are some circumstances where you don't even need the 50%. Some important bylaws that you may have in your condo. One of them is a standard unit bylaw, which deals with insurance and what is the basic unit and what is a betterment. You may have a mediation arbitration bylaw. If you are going to borrow money, you will likely need to have a borrowing bylaw. So bylaws have to be reasonable, and they have to be consistent with the declaration. So they cannot be inconsistent with the declaration. The declaration doesn't have to be reasonable, but bylaws do. The next document that you'll find at your condo are the rules. Now, the rules, usually we talk about the rules covering the 3 Ps, people, pets, and parking. And really, they create the do's and don'ts in your condo, the standards of behavior that are going to be accepted in your specific condo. They'll deal with aesthetic issues like whether or not you can put lights out at Christmas, or whether you can hang something on your door. They'll deal with noise and nuisance issues. They'll deal with things like if you're going to make renovations in your unit, when can that happen? The board will decide the rules. The board does not have to get approval from the owners to pass rules. So the board passes the rules. They then send a notice out in accordance with the act to all of the owners. And if nobody requisitions a meeting, those rules take effect within 30 days. Now, owners, if they don't like the rules, they can requisition a meeting, and then those rules go to a vote at that meeting. Rules have to be reasonable. They have to be consistent with the bylaws and the declaration. And the other thing that differentiates rules from your bylaws and your declaration is the declaration and your bylaws are registered on title to your unit. So if you were to search title, you would find the declaration and the bylaws. But the rules are not registered on title. So if you need to find out what the rules are, you can make a request for that document from your condo, usually through property management if you're property managed. Or you're going to have to ask the directors for those rules. And then the final thing I'm going to talk about is policies. Now, policies, there's a lot of controversy about policies lately. Policies are an informal document that they're not even mentioned in the Condominium Act. Really, policies should be about procedures, how the board goes about dealing with things. So you may have a policy on how you collect common expenses that are in arrears, for example. But policies, there's no way to enforce policies. So if there's something that you want it to be able to enforce as a rule in your condo, you need to make sure that that gets into your rules or your declaration. So the board implements, they design the policies, they don't go to the owners for a vote. They're not registered on title. They're very informal, very easy to change. All right, so that's it for the condo documents. And we're now going to move back to Ashley Lamb, who is going to talk to us about status certificates. Ashley?
Great. Thank you, Sonja. So a status certificate is an important document, legal document, which may be requested by a purchaser or any other interested party. Normally, the status certificate is requested through property management, as Sonja said. If you do have a property management company, or if not, if you're privately run, then by a director. It takes the property management does actually have legally 10 calendar days, not business days, calendar days, to prepare the documentation for a standard order. The cost is $100 and plus HST, and they will actually not start preparing it until the full payment has been processed. Many property management companies do offer an expedited service, so 2 or 5 days, but that does come at an additional cost. You can't get the expedited service at $100. The majority of the status certificates now are ordered online, and most are passed along electronically. To be honest, I don't actually remember the last time I had to physically walk into a property management office and drop off a physical check and then go back and pick up the hard copies to then go and deliver physically to the lawyer for review. So times have changed. In the status certificate, it includes any special assessments that might be planned, if a unit owner has paid their maintenance fees or if they are in arrears, details of the reserve fund, if there are any judgments against the corporation or if the corporation is in the middle of a lawsuit with a unit owner, the number of units that are leased in the complex, a copy and proof of the condo insurance. And it also does include copies of the declaration, rules and bylaws, and the budget. Lastly, a lot of people don't know this or do, but don't think of this, but the status certificate is only actually valid for the date that it's signed. So one thing I do want to mention is that, especially in the fast-paced real estate market that we're in, where condominiums are at such a high demand and we have such a low supply, and units are selling rather quick, normally within 5 to 7 days of being on the market, a lot of owners and their real estate agents are actually ordering the status certificate in advance. And the reason why they do this is so that they can have minimal conditions in their offers, which is great. And it is good to show the buyer in advance the documents so that they can review them in advance. But if you are going to pass along the documents, I would just maybe ask if they're listing right away and just remind them that don't be surprised if the buyer's lawyer comes back and says, well, this is out of date. This was signed a week ago, because things can change within a week in a condominium. So that's just something to think about. And that's it, Sonja.
Thanks, Ashley. Those status certificates are so important from a buyer's perspective, but also from the condo perspective. That information binds the condo. So it's really important to make sure those status certificates are accurate, because everybody's going to be relying on them. All right, so back to Ashley number 2. Ashley Winberg is going to talk to us about how you can request documents. So I mentioned some condo documents in my presentation, and I told you that you need to look at them. So if you don't have them handy, Ashley, how do you get condo docs?
So there is now a mandatory form that is available on the CAO's website, and it's a request for documents form. So that form needs to be completed by any unit owner or mortgagee requesting a document, condo document, a record, and that can be completed and then deposited either in the corporations if there is, an on-site Dropbox, or by mail or courier to the corporation's address for service, or to the property management office, depending on the manner in which the board has advised owners they are to communicate with the corporation. So once the corporation receives that request, the corporation has 30 days to respond. So the board has to fill out, again, it's another mandatory form that stipulates the board's request to the records request. Now, for each document that's being requested, each record, the board has to stipulate in the board's response whether or not, again, it's a mandatory form, so it's easy-ish to fill out. The board has to stipulate whether each document is a core record or not a core record. And the board also has to stipulate if there are any documents that the board will not be providing, any records the board will be not disclosing, the reason why, and specifically citing the relevant section of the Condominium Act in Section 55. So records or portions of records that are exempt from disclosure include records or portions of records that pertain to contemplated or actual litigation, employees, with the exception of employment contracts, other unit owners or other units. So there's also a couple other things in the regulations, such as legal opinion letters that pertain to other units, other unit owners, or actual or contemplated litigation. So if you do receive a records request and you are concerned, can inquire with your property manager, and if they have any questions, inquire with your legal counsel. So once the board fills out those two things, the board also has to advise whether or not in the form there will be a charge for the records requested. Now, if the individual is requesting a core record, and a core record is essentially the corporation's declaration, bylaw rules, board meeting minutes, and owner meeting minutes for meetings held within the preceding 12-month period, the most recent reserve fund study plan, the most recent financial statements, and the most recent auditor's report, and the one that gets requested most frequently, the record of owners and mortgagees. So that's the unit numbers and the names of each of the owners and mortgagees and their mailing address. Anything that's not one of those or not defined as a core record in the Act and the regulations is a non-core record. So for core records, the corporation is not permitted to charge any fees if the individual is asking for them in electronic format, which now is typically the case. However, if the owner is asking for a copy of a core record in paper format, the corporation is permitted to charge 20 cents and maximum of 20 cents per page, which is really just a printing fee. So for not core records, for instance, copies of a board meeting held 2 years ago, the corporation can charge the individual for a reasonable fee to reimburse the corporation for labor and delivery costs and photocopying charges that do not exceed 20 cents per page. So labor delivery costs, really, they're more pertain to the need to redact the document to ensure that no confidential information is released or any information that is exempt from disclosure, like information that pertains to actual or pending litigation or other unit owners, as I discussed previously. So once the board's request is given to the unit owner then has 60 days upon receiving that response to complete the bottom of the board's form and submitting it, along with any payment that's required based upon the board's response. If the individual does not respond within 60 days, their records request is deemed to be abandoned. So let's say the corporation gets the individual's response and payment within the 60-day period. Once that response is received and payment is received, if it's a core record, the corporation has to provide that within 7 days. And if it's a non-core record, it has to be provided within 30 days. Something that is often overlooked is that for any portions of a document record being provided that are redacted, so they're blacked out because it's confidential, for each and every single redaction, the corporation has to state why in a separate document, why it's being redacted, particularly it's confidential, exempt from disclosure, and the relevant section of the Act that exempts that information from being disclosed, which would be Section 55 of the Condo Act. So that's something that's important to keep in mind that's often forgotten. And that's in the regulations to the Act. And the corporation must also, when we're giving the documents, advise whether or not, well, number one, what the actual cost of delivering and providing the records is, if any, and if there was a difference between the estimated cost, the corporation's estimated cost in the board's response and the actual cost. And if the actual cost is less, the corporation has to pay, reimburse the difference to the requesting party. And if the actual cost is more, the requesting party only has to pay a third 10% of that. So it's capped, and that has to be provided within 30 days. And let's say a corporation does not comply, either does not provide the records requested, does not, just doesn't respond, or doesn't stipulate the reasons for the various redactions. The maximum that the corporation could be fined is now $5,000. It used to be $500, but it changed in the end of 2017 to $5,000. And I think that's it for now, unless there's any other questions on that topic.
Yeah, actually, Ashley, there is a question in the chat about how much time does the board have to respond to the request?
Okay, sorry. Okay, so the board, let's say you get the form, you have 30 days from getting the form to respond. And then if it's an electronic record, there should really be no reason why it shouldn't be provided within that 30-day period.
There's a lot of days that you have to remember, but the very first one is you've got to respond within 30 days. Yeah, great. Thanks, Ashley. So we are now at our first question period. If anyone, I just want to give people a heads up. There are a couple of questions in the chat. We'll try and get to them. But if anybody has any questions specifically for Ashley Lamb, who's our real estate condo guru, she has to leave after the question period. So if you have a question specifically for her, make sure you ask it in this question period time. So I see someone's raised their hand. So I'm going to unmute you, and or you can unmute yourself and ask your question. This is E. Scott.
Yes, the basic information you given tonight is fine, but you didn't go into the significant difference between a common element condo development and a horizontally built standard condominium, where the purchasers, through their condo corporation, become responsible for the roadways and the underground infrastructure. In the case of our group here in Huronia, certainly our lawyer and the realtors involved did not forewarn us of the significant differences. We've had a committee for the past 4 years trying to fight City Hall, now trying to take it to the province to get the Condo Act amended to eliminate the use of common element condos as a means of property development, because what it does, it transfers the responsibility long-term for the roadways and the underground infrastructure from the municipality to the unit purchasers. And who knows what the cost will be long-term in that regard. The city gets full property taxes from each unit as if they were a standalone home of equal impact assessed current market value. And yet they do not provide full services. And in the case of a group here in Huronia, we've discovered that probably 30% of our taxes go to subsidize other property owners because of the services we do not receive, but are responsible for through our condo corporation. And there doesn't seem to be any interest in CCI, from what I've seen over the past 5 years, Huronia chapter or nationally, to deal with this difference.
Thanks for those comments, Scott. And you raise an important point in that you really do need to understand what it is you're buying. The legislation allows for common element condos, and they do exactly what you say they do. CCI has been involved, and I'll ask any of the other board members if they want to jump in as well, but CCI has been involved over the years in terms of the double taxation that not just common element condos face, but condos generally face. Mm-hmm. There's a lot of services that condos have to pay for, sort of double. A couple of years ago, garbage was a big one. So those are valid concerns. Realistically, I think changing the legislation to eliminate common element condos, I'm not sure that that's going to happen, but I'm going to open the floor up to any of our other board members. If you want to chime in, there's a lot of board members who've been around for a long time and have experienced hearing the same time of comments and complaints that you've raised. Anybody else want to join in?
Yeah, I'm happy to join in there, Sonja. CCI, in my time frame, has certainly been involved in many government outreach programs trying to convince the politicians of local municipalities that there are differences in condominium living and that the differences are to the benefit of the municipalities, and that benefit should be recognized in a variety of forms, including reduced taxes or improved services. And we have made some headway, particularly in the Barrie area, with regard to recycling initiatives and so on. And the Brantford group in the Golden Horseshoe chapter also got some concessions on both property taxes and the fees for garbage. And there's a group over in just outside of the Kitchener area that was able to convince their municipality to not charge them the waste levy that they had in their local municipality. So while it's a noble cause to try and change the provincial act, a lot of these things are local municipal decisions. And so it's important to build those relationships, as CCI Huronia has done with people like Mayor Jeff Lehman in Barrie and a variety of councillors in other municipalities, and just keep hammering home the message. And so, yes, we are very interested, and our government relations group is interested in doing that. And we're always looking for volunteers who have the knowledge and who maybe already done some of the outreach to support our efforts in that regard. It'd be great to pick up that cause.
Anyone else want to chime in? Ashley, go ahead.
If I could.
Oh, okay, Ashley, and then Jeff.
Well, I was just going to mention that the issues with underground services, that's also an issue that, regular standard condominium corporations that are high rises also face. However, my firm, we've been successful in getting some municipalities to reassume responsibility for underground water mains and storm sewers that the corporation, unfortunately, was required to take over based upon its documents. But it is possible. It just requires a lot of negotiation.
Jeff?
Yeah, so a couple quick points. Some of the municipalities we operate, our headquarters are in Collingwood, and we've seen rebates or reduction in taxes for condominiums in the area for certain services. Blue Mountain, they don't pay the education portion of tax in the village at Blue and other resort style units there that are not primary residents, for example. Simcoe County, we also see waste and recycling rebates issued to condominiums that qualify, that help offset some of those municipal taxes. I think more effort should be made to force developers to better educate purchasers. There was some initial movement to do so with the amendments in 2017 to the Act and some bare minimum requirements, but time and time again, we see a developer build something. Either they've hired an outside sales force or they have their own sales staff, and they're not providing the purchasers with a clear picture of what they're purchasing, and providing them a disclosure document and not explaining it to them and not encouraging them to seek legal opinion on what they're purchasing often leaves the homeowner not clearly understanding what it is that they've bought and what their responsibilities are ultimately.
Thanks, Jeff. And that raises another really important point. When you're buying a condo, it's really important that you're dealing with professionals who have experience in condos. Condos are creatures unto themselves. So you want to be dealing with real estate agents who know condos and work with condos all the time. You want to be dealing with real estate lawyers who handle condo transactions all the time and are familiar with condos. Not every lawyer, not every real estate agent is an expert in condos, and you want to definitely search for those people who have expertise in this area, because it is a special niche area. All right, any other board members that want to chime in, or we'll move on to the next question? All right, so the next question we haven't talked about PICs. But we do have a question about PICs, and I'm going to put this to the property managers. So Jeff and Debbie, the question is, why would a property manager ask corporations to waive the issuance of PICs? Our property manager introduced a motion at the AGM to do so. I thought this could only be accomplished by all unit holders' written annual consent. So Debbie or Jeff, can you chime in there and first just explain what a PIC is and how you can do away with issuing a PIC? Debbie, go ahead.
Okay, go ahead, Jeff. I have to be perfectly honest. My staff do the PICs, I don't, so my information might not be perfect. However, here's the questions I get at my level in the company. How come the information is so old? How come we didn't get it sooner? What's in the reserve account right now today? This document isn't telling me that. Why do you keep sending it to me? I don't understand it. I don't want to hear it. So we do hear from owners that they want to pass a motion and they want to get rid of getting this data into their inboxes so frequently. And their attitude is, if they want to know, they'll ask. Jeff, do you have any comments on it beyond that you might share?
Similar to yours, actually. A lot of owners that, why do you keep sending us this? It's a waste of paper or waste of time, or filling up my email inbox, depending on how they receive it. And then, statistically, I think it was ACMO actually that did a survey last year or the year before on it. People see the same thing over and over every 6 months, and then when there is a change in a information certificate update comes out, because there is a change in the board, change in insurance budget, what have you, that triggers an ICU. They think it's the same thing. It's on the same kind of government letterhead with the Ontario logo at the top and masthead, and it goes straight into the garbage as well. And a lot of the government forms have been less than ideal. The PIC was a response to provide owners with more communication that they requested leading up to the amendments to the Act. Unfortunately, the PIC does not deliver what the owners really want. And most of our clients feel that periodic newsletter doesn't have to be fancy, just something simple, bullet form even, this is what we've done, this is what's coming up, this is our financial position, and this is your board of directors, and sending it out every 2 or 3 months seems to be the sweet spot, keeps the owners quite happy and answers most of their questions.
All right, so just so everyone understands what a PIC is, because it's lingo that we use in the condo world, but a PIC is a periodic information certificate, and it is required by the Act to be sent out twice a year to owners. And it has certain information that has to be put in there, and things about the board, the finances, insurance, legal actions, etc. So there is an exception to having to send it out, but you need 80% of unit owners to consent to it in writing. So passing a bylaw is not a way to do that, in answer to Ian's question. All right, so we have another question, and Ashley Winberg, I'm going to pass this one to you. The question is, can you request to see the votes and proxies, not who voted, though, for the election of directors at the AGM? So can you ask for the votes and proxies?
Yes, you can. That can be a record that can be requested. However, the names, and if anyone indicates like their unit numbers, that has to be redacted. But yes, that can be requested, and it generally would be considered a core record. For me, that was held within the last 12 months.
Thanks, Ashley. All right, Pat, you've got your hand raised. If you want to unmute yourself and ask your question.
Ashley, I had a couple questions regarding section 37 and section 132. Okay. So I did, several years ago, the condo put up, without any notice, put up a playground on our condo property. And so it was questioned in a later subsequent board meeting. Anyways, so there's a committee struck, and long story short, the committee came up with recommendations and tried to meet with the board literally for years. The board kept refusing to meet with them. We had to take it to the Condo Authority of Ontario to get a request for records regarding any records about minutes or any records regarding the playground. It ended up having to go to the Condo Authority Tribunal. All the way through, the board was just obstructive. And even though eventually the tribunal went to a stage 3 adjudication, the tribunal came out with and it ended up one of the issues was minutes and redaction of minutes. There's a whole big issue about that. They just end up redacting because they didn't want to give any information. Anyway, so the Condo Authority CAT found on my side, because I wasn't. And so what happens? So they get 30 days. Here's the decision. 30 days. So it allowed some money. Supposed to come up with these for redaction. Anyway, so but the board.
Pat, can I just interrupt you? Can you ask your question?
Okay.
Because we're just a bit tight on time.
Okay. It's a word of caution. So even though the CAT found in our favor, the board just kept. They didn't care. They didn't respond. So so the CAT doesn't enforce its own decisions. So you had to take it to a lawyer for what's the word? Because anyways, I was interested in under you said mediation arbitration bylaw. So under section 132, it says they deem that there is something for mediation arbitration. But is there an example I can see of how that bylaw may be worded? Does someone might have an example for that?
Okay, so in relation to a mediation arbitration bylaw, Pat, you would probably need to reach out to a condominium lawyer. That's usually who would be drafting those types of bylaws. So that would be one place to start. CCI doesn't have sort of a precedent for bylaws because there's a lot of things that have to be looked at and they're very specific to each condo corp. So the best thing would be to reach out to a condo lawyer and talk about what should be in that type of bylaw. All right, so we're going to move on. We're slowly running out of time. So we'll try and see, we will have another question period at the end. And so we'll see if we can try and get to some of these other questions that are in the chat box. And if anybody has questions that they want to ask live, again, you can put your hand up and do so. So we're now going to move on to the topic of owner meetings. And we have Jeff Struing, who is a property manager out in Collingwood with Shorter Slope Property Management, who's going to talk to us about unit owner meetings. Jeff, take it away.
Great. Thanks, Sonja. There are several types of unit owner meetings. Your primary one is your annual general meeting. They are required to take place annually and must be held within 6 months of the end of each fiscal year end. The AGM timing, content, notice of meeting is all legislated in the Condominium Act. Amendments to the Condo Act in 2017 introduced prescribed forms for the pre-notice of the meeting, the meeting notice itself, and the proxy form that should accompany the meeting notice. The agenda for the AGM must include approval of the previous AGM minutes, presentation of board approved audited financial statements and auditors report, as well as election for directors. Other items may be added to the agenda. Information meetings are often referred to as town hall meetings. They are not legislated and don't require the prescribed forms, but do not allow voting by owners or conduct of business as you would at an annual general meeting. Information meetings can be very useful to inform owners of future projects, seek input from owners on how to improve the community and build a cohesive community while building trust in the board. Consider an information meeting to inform owners of upcoming amendments to declarations or bylaws. As Sonja indicated earlier, getting consent for a declaration amendment is very, very difficult. So the more information that you can provide to the owners in advance and give them opportunity to discuss and become comfortable with it when it comes time to the annual general meeting or potentially a special general meeting, it's a more informed, comfortable decision for the owners to exercise their vote. Requisition meetings don't happen near as often, thankfully. They must follow the legislated notice requirements as well, using the prescribed forms. Requisition meeting is required to take place when at least 15% of registered owners make a requisition for a meeting in writing and include the nature of business to be presented at the meeting. Often the requisition meeting might be called for the removal of one or more directors. They're never fun. In this case, the written request must also include the name of each director proposed to be removed and the reason for their removal. There is also special general meetings. Sometimes if you have a bylaw to be approved, it's often more efficient to have a separate meeting, a special general meeting with just the agenda item of approving that bylaw. Trying to pack it into an annual general meeting, which often has enough items on the agenda, is not as successful. So our experience is a special general meeting for the express purpose of approving a bylaw or bylaws, declaration amendment, can often be more successful and is usually in the end more efficient. Set expectations. Sorry, Sonja, next slide, please. Provide clear and timely communications to the owners, use the prescribed forms, provide a detailed agenda and allow sufficient time for questions and answers after the required agenda items. Set out guidelines in advance and moderate to keep everyone in order. Try and avoid having 5 people speaking over one another. It's never productive. Consider sending any board reports or other handouts out in advance of the meeting. It makes for more efficient meetings, but it also helps for owners who are unable to attend to review the materials and potentially exercise their votes via proxy. Nowadays, we're seeing a lot of electronic voting with virtual meetings and so on. And next slide, timing. For delivery of the preliminary notice, deadline for receiving the owner input and delivering the notice of meeting are now prescribed by the Condo Act. Consider electronic delivery whenever possible. Obtain the consent to receive notices electronically from the owners. Right now, we're able to send notices electronically under temporary legislation due to the COVID pandemic. But eventually we probably will see it revert back and the consent forms should be obtained. I know there's an effort to make electronic and virtual electronic voting, virtual meetings permanent, and the temporary legislation would become permanent. But the consent to receive notices electronically is not included in that. So it's still important to receive those. On the screen, you'll see pictogram of what the notice periods are. We recommend adding a little additional time if you have a number of owners that need to receive their notices by postal mail, as it can be slow, and having at least 1 day for compiling owner inputs not really sufficient. So push out the pre-notice, shoot for 40, 42 days in total, and give yourself a 2 or 3 day buffer there to collect and compile information before sending out the formal notice, which needs to go out at least 15 days prior. So, and when you see at least, add a day or two onto that, because that's full days, not the day of. If you mail it out at noon on a Monday, that day is not included. So back to you, Sonja.
Thanks, Jeff. And yeah, that's a really important thing to remember, that those are minimum days. So there's nothing wrong with adding in some extra days for buffers so that you're not scrambling, trying to make sure you meet the minimum requirements. All right, so now we are going to hear from Debbie again, and Debbie's going to talk about property management versus self-managed, because not all condos are professionally managed by property managers. Some are self-managed condos. So Debbie?
Yeah, great, thanks, Sonja. Certainly in Northern Ontario, we encounter a lot of self-managed condominium corporations, and the folks that can do it, good for you, and I'm extremely impressed. It's a difficult task, but honestly, if you've got some dedicated directors and they're willing to roll their sleeves up, get educated on condominiums and pitch in, I think it's a really successful management platform, again, for smaller sites. Self-management, there's pros and cons, of course, there is with everything. Some self-managing boards don't like the liability that they're under without having a management company to make some decisions with them. They feel a little exposed if they're looking at hiring trades in terms of coming up with the right clauses in trade contracts. Some self-managed boards struggle a little bit in determining what market value is for services because they don't have a large management company sending out a bulk tender on their behalf. So really some ups and downs and pros and cons on that. The question I get the most from self-managing boards, especially a couple of years ago when all of the legislation changed and the Condominium Management Service Act came into being as of November 1st, 2017, is, oh my God, we can't self-manage anymore because we have to hire a management company because the government says. That's not true. If you still want to self-manage, there's absolutely nothing wrong with that. You just can't pay a director to self-manage because that is then in breach of the Condominium Management Services Act. So we kind of move on from that management style of self-managing into what's called direct hire. So under the Condominium Management Services Act, you can certainly hire a licensed manager that's licensed with the Condominium Management Regulatory Authority of Ontario, or CMRIO, and you can pay that manager directly as an employee of the corporation, or they may have, another way to work for you. It's certainly legal. There is a limit, however, to the number of corporations that one manager can work for without having what's called a principal manager over them, or a government or a management services license. So a couple of intricacies to work out there. But again, I see some boards are very successful on that avenue. And if so, as long as you make sure you've got some errors and emissions insurance tucked in there somewhere, it can work really well. The other option, of course, is just hiring a professional management company. I find this tends to be the preference of usually larger corporations, although I have to say that a lot of, I won't say older, I'll say more mature properties are leaning this route because they're running into, a little more challenge than you do when the site is, 5, 10, 15 years old. Certainly that's something to look at. I would say my best advice for what it's worth, if you're looking at hiring a professional property management company, is for the board to sit down and come up with a, what do we need? What do we want? What can we afford list? Then you hit the market knowing what you want, what you need, and put some boundaries on what you can afford and make all of those pieces fit together. Once as a board, you've sorted that out, then you're well poised to go to the marketplace and see what you can afford, what you can buy, and what services offers you can get. So a request for proposal for services is a great way to approach it. It's almost like making a grocery list before you hit the grocery store. The other item we need to touch on just briefly before going on to the next slide is mandatory licensing. So you have to be licensed in order to provide condominium management services in the province of Ontario. So under the CMSA, the Condominium Management Services Act, there's a list of very key things that you cannot do without a license. So you cannot collect the condo fees. You cannot sign contracts on behalf of the corporation, etc. So there's some items to look at there if you're going to go manager shopping to understand what you can hire someone to do, whether or not they need a license, and what you can do on your own sort of for free as a self-managing board. Next slide, please, Sonja. The next thing that we need to talk about when we're thinking of property management is, who's in the driver's seat? So I like to think of it this way. The board makes the decisions. The board issues the directives. The board approves the trades. The board approves the minutes of the meetings. The board approves the color of the flowers going in, unless they want to delegate that down. The board is in charge. So while the property manager may help you drive the car, the board will actually steer it and figure out where it's going. The board is doing the planning. So the property manager then, whether it's an employee of or a company or someone that works for a management firm, they're going to implement or put into action the directives of the board. And it's key to understand the two. The property manager does not make your decisions for you. The board makes the decisions. The role of the property manager is to put enough information in front of you as a board of directors so that you are then able to make informed and educated decisions that serve the best interests of the corporation and the community that you're volunteering for. And certainly your manager should be obtaining quotes for you, tendering, and being a really good representative of your community. And Sonja, really, I think that's about all I have to offer on this. I believe that Jeff is back up next.
He is. And thanks, Debbie, for that. And, one of the biggest changes that came about with the changes to the Condo Act was the implementation of condo managers having to be licensed. And it's really, really important that if you're going to hire a manager, that they are licensed, because if you're hiring someone that's not licensed, you're actually breaching the Condominium Act, which requires boards of directors to hire licensed managers or go the self-managed route. All right, Jeff, back to you. And you're going to talk about the annual plan and what things condo boards and just condos generally should be thinking about when planning.
Helps if I unmute. Thanks, Sonja. So depending on the type of condo, the annual plan can be quite complex, or it could be quite simple. Condos have many events that occur throughout the year, annually, sometimes more frequently. An annual plan should lay out important dates, things like your AGM, package to be sent to the auditor, meeting notice, deadlines, of course, preparing and approving the operating budget. It is also good practice to review contracts and service agreements annually, usually in preparation for budget is a good time. Same thing with the reserve fund study, looking at the plan and making sure contributions and balances are in order, but also looking at what reserve components need to be addressed in the coming years and setting out a plan to do so. Investments should be reviewed routinely as well. Sometimes that's the treasurer, sometimes it's full board, but at least once a year, it's good practice to review. Consider a preventative maintenance schedule for common element components. Fire alarm testing and fire drills are required annually in some types of buildings. Have an aging roof, maybe having it inspected each year. Can save on expensive leaks over the winter months or rainy spring. Perhaps you provide a quarterly newsletter or every other month newsletter to your residents, put it in the calendar. While you're filling in the calendar, don't forget the CCI Huronia 2-day intensive director course each spring. It's great for new directors or refreshing directors that have been on the board for a while. Many boards will set out board meeting dates for the year following the AGM. Some boards like to meet, third Thursday every other month, or so have it, or if it's quarterly meetings, plan them in advance, and that way there's ample warning to the board members. Having a good plan in place will help things run more smoothly and provide a roadmap for new directors in the future as well. So keep it as a living document. Excel spreadsheet works well for preventative maintenance schedules if you don't have other electronic tracking software to do so. And it can be passed on from board member to board member as directors change, and it provides them good guidance how to continue with the maintenance of the condo corporation. That's all I have. Back to you, Sonja.
Thanks, Jeff. Well, there'd be no discussion about condos without a discussion about money. And tonight we have Blair Spinney with us, who is an auditor, does a lot of work for condominium corporations as an auditor. And he's going to talk to us about budgets, money, and banking. Blair?
Thank you very much, Sonja. So budgets, yeah, first of all, let's talk about getting money in the door, as it were. So budgets, common elements, assessments, and collecting those assessments. So the budget really is broken down. You've got a budget for your operations, and you've also got an allocation for the reserve fund. Now, John's going to be talking about the reserve fund shortly. He'll go into a lot more detail on that. But those two amounts, the operations and the allocation to the reserve fund, is what determines the common element assessments paid by the owners. So the budget is set annually, does not require the vote of the owners, and it's usually a process that begins a couple months before the end of the year for the following year. So it's important to get that process started on time to make sure you have all the information. Once the budget is approved by the board, a letter should and a copy of the budget should be sent to every owner. For large increases, the board should increase holding an owner meeting after the budget has been prepared to explain it. It's always better to come clean on these things and be transparent as to why there is such a large increase. So once the assessments have been in place, the industry standards that owners pay by either post-dated checks or more often is pre-authorized payments. Cash should never be accepted for common element assessments or any other payment owed by a resident or owner. Now, if an owner defaults on the payments, of course, I won't go into a lot of detail about liens tonight. But the corporation has the right to register a lien against the owner's unit. And with that lien is actually is above, comes before mortgages and whatnot. So the owner's assessments are protected. And just about talking about not going into a lot of detail on these things, and I think a few other people have been alluding to it. These topics, for instance, I'm talking 10 minutes about money, but when we do the course in April, it'll be close to an hour. So you'll have to listen to me for an hour if you come to the full course. So once we get the money, I guess the next thing is talk about getting it into the bank account. So under the Act, the corporation is required to maintain at least one bank account for operations and one for the reserve fund. So the fee should be collected on the first of the month and deposited into the operating account. A transfer for the reserve fund portion of this payment should be made the following day, because really the money is supposed to be deposited straight into the reserve fund. So now that we've got the money in the bank account, let's talk about spending the money. And it's important when we're talking about spending and making sure we're receiving money to think about internal controls. I'm an auditor. Internal controls are important to me. So let's talk about check signing. Now I'm going to talk about check signing, but what I'm going to talk about applies equally to electronic payments because the same sort of controls can be put into place for electronic payments. So first of all, utility payments. It's easiest to do just a pre-authorized payment for those. You don't really have a lot of choice. They should just come straight out of the account. For the signing of checks or electronic payments, you've really got three options. One is to have two directors sign. Now, in the case of self-managed, that's the route you're going to go. And in that case, it's probably good to have the check signers being directors that aren't really involved as much in the purchase and receipt of services and supplies and whatnot. So that way you're segregating that component as much as possible. The other alternative, if you do have a management company, is to have two officers of the management company sign each check. So there, the directors aren't getting right involved into the disbursement of the funds, but there are what we call compensating controls that can be put into place to make sure that, these were the transactions that are taking place are under the authority of what the directors have authorized. The other alternative is to have one director and one officer of the management company sign each check. And that way, the management company signs off on the disbursement for what they know, and the director will be signing off on behalf of the board. So those are really three options there. One thing that should not happen, if the site manager is the one in charge of procurement, they should definitely not be signing checks. That would be a breakdown of segregation of duties. So let's talk next so we've talked about getting the money in, we're talking about spending it, now we've got to account for it. So let's talk about financial statements. I think that's on the next slide, is it not?
Yep.
Yes, monthly financial statements. So these financial statements are usually prepared monthly by the management company, reviewed at the board meetings, and they evaluate the budget versus actual. So how are we doing versus the budget? So each member should receive a copy of the statement. The statements should include a balance sheet, income and expense statement, an arrears schedule to make sure everyone's paying their fees, a bank reconciliation for both the operating and the reserve bank account. So that's a minimum. So that's this. Make sure we're getting our common element expense collections in, and we're expending the monies as per what our plan is. The other thing too is, now that we're coming full circle with this, we got to report back to the owners. So they wouldn't get your monthly financial statements. So at the end of the year, you generally send them the external financial statements. Now, these are general purpose financial statements for the owners and potential owners. So these people don't generally have full access and knowledge concerning the finances and operations that the management and directors have. So they will need more information about the uncertainty that the corporations face, estimates that are made for accounting, any contingencies or risks that are the corporations face. They want to know about future cash flows. And of course, that's a big part of what the reserve fund is for. Details on obligations and commitments. And there's a general presumption that all the transactions are at arm's length. So that means two people negotiating at arm's length. So related party transactions, if there are any, should make sure the details of those are disclosed to the owners. Generally, the statements are audited. I won't get into a lot of detail on what takes place in an audit tonight, but check out our director's course, and we'll definitely be covering that then. That's what I get. I hope I'm okay for time.
Thanks, Blair. There is a lot to talk about when it comes to money. Speaking of money, another aspect of money that affects condos is their reserve fund, because you're putting money into it. And we have John Just with us tonight, who is another long-term CCI Huronia director. He's with McIntosh Perry, and he is one of our very knowledgeable persons when it comes to reserve funds. So John, can you talk to us about what the reserve fund is, what a reserve fund study is, and just give people a sort of a general overview in less than 5 minutes, because I know this topic is another topic that could go on for about an hour discussion. John?
Thanks so much, Sonja. And just a quick shout out to all the property managers, both speaking tonight and in the audience. The pandemic has been particularly hard on all of us, but property managers are an essential service. Day, night, and weekend, they've been keeping our condominium communities safe, sound, and sane for the most part. So thank you very much. Listen, reserve fund planning, on a high level, there's three things that you have to think about. There's the actual fund itself. There's a study that you need to do and a plan on how to fund the fund. And it just keeps going round and round in circles. So the fund itself is a separate account, as Blair said. It can have investments as part of it. Those investments are limited under the Act to very, very safe investments, so you don't lose your principal. So in other words, they don't earn a lot of interest. So if you're getting anywhere between 2 and 4% on your investments, you're doing a good job. The money in the fund can only be used, it's an exclusive fund, it can only be used for replacement of common elements or major repair to common elements, and nothing else unless you dissolve the corporation. That rarely happens. So you want to make sure that you're getting it right. And the way to get it right is to get a study done. The studies are, again, dictated by the Act to be independent studies done by 8 classes of people: engineers, architects, engineering technologists, architectural technologists. Those 4 groups have laws that govern their behavior and their code of conduct. The other 4 are quantity surveyors, certified reserve planners, appraisers, and Ryerson grads. They govern themselves according to their own standards. And of course, Ryerson grads are Ryerson grads, and they usually are working for one of the first 4 that I mentioned. The main thing is that these people have no conflict in telling you the straight goods on what needs to be done to your common elements. And to do that, they have to estimate how long things are going to last, the longevity of those common elements, and what the costs are. And typically, the costs are established in, the immediate term. What would the likely cost of doing this work be today? And then inflated over a period of time. In fact, the Act again dictates a minimum of 30 years, and the movement is afoot to get that to at least 45 years and possibly 60 years. We've been offering our clients 60-year options for a long, long time. Which leads to the whole reason why you do a study is to prepare a plan called a notice of future funding. The notice of future funding is a notice. Some people may remember it as the Form 15 notice. It's a notice that is attached to the status certificate, and it lays out exactly what the contributions to reserve are over the next 30 years minimum. And ideally, those would be, in a perfect world, everybody would know everything forever, and we would just be matching inflation and everything would be rosy-posy. That changes. As governments come and go and as economies go up and down. So every 3 years, you have to do an update. And so every 3 years, you repeat that whole process. You look at your fund, you look at your study, and you look at your notice of future funding. The annual contributions are mandatory. Blair's going to, as an auditor, he's going to look at it and say, hey, your plan said you were going to contribute this much. You better contribute that much. And if not, I'm going to write up a paragraph about it. The spending is a little bit more flexible. Reserve fund planner might predict that the paving has to be done, and the board might walk the paving and say, you know what, we're not going to do all the paving, we're just going to do these potholes. So there might be some flexibility there. And, we encourage our clients to ask the questions about, is this a necessary expense? So of course, contributions minus spending should equal a closing balance. Hopefully you're contributing a little bit more than you're spending, or if not, you're depleting whatever balance you've built up. The goal of the plan, the notice of future funding, is that you never have a negative balance visible in your 30 years, 45 or 60, depending on what you're doing, that you're slightly above zero, but not too large. You want to just find, like the 3 bears, you want to find just the the contributions that are just right so that you're getting enough of a balance to have some level of safety. There's been a movement afoot to have your balance roughly equal to, say, 3 times your insurance deductible, so that a business case can be made. Do we even want to make a claim if it's related to property damage that's common elements, just to keep those insurance premiums down and make sure you still have qualify for coverage in the future. And then, as I said, repeat. So there's only 3 things to remember. You have to have a fund, you have to have a study done by independent people, and then you have to develop a plan from that. And even if you disagree with the independent person's plan, you have an option to implement your own plan called, the differences paragraph at the end. But the 3 takeaways: fund, study, plan, repeat every 3 years. Back to you, Sonja.
Thanks, John. And, we get a lot of people say, why do we have to put this money into the reserve fund? I'm going to sell my condo in the next 3 years. I'm not going to get any benefit of it. But that's the whole purpose of the reserve fund, so that everyone who gets to use the common element shares in the costs. And if anybody needs a reason why you need a reserve fund, just take a look at the news this week about the condo in Toronto who doesn't have enough money to do major repairs, and owners are looking at losing their units because they can't pay for the special assessments.
Yeah.
So
to put that headline in context, if every one of those owners had saved an extra $75 per unit per month, there would not be a news story. They would have been able to afford the work today.
Yeah, very unfortunate situation. All right, moving on, because we are quickly running out of time now. I'm going to throw it back to Debbie, who's going to just give us a brief overview on condo insurance. This is, again, is another topic that we go into great depth in our director's course. There's a lot to talk about with respect to condo insurance, but Debbie, can you give us some of the basics?
Sure. Yeah, very quickly, Sonja. So insurance could probably be an entire 2-day session all on its own lately. However, you need to have insurance on the common elements and the standard unit. A standard unit bylaw is a great idea. You must insure for all major perils. You can get all kinds of extra insurance as a condo owner. You can get insurance against special assessments. Lots of stuff to look at there. The unit owners need to have their own insurance. I had a flood in a building some years ago. The owner didn't have insurance. It cost them $122,000 because they didn't have insurance on their condo unit and the items in it. If you don't have an appraisal in Ontario, condominium corporations must be 100% insured. So if you don't have an appraisal, how do you know you're 100% insured? And to quote an insurance broker that has spoken at a seminar I attended about 10 years ago, he said, hey guys, guess what happens? If you only have 60% insurance on your property and the fire hits the building and it's all gone, which 60% do you think the insurance is going to cover? Because they're only going to cover 60% of it. So give it some thought, get an appraisal. And Sonja, I know we're pressed for time, but really this will be a great topic at our April 2-day director's course. And back to you.
Thanks, Debbie. Insurance is such a hot topic in the condo industry because they've been hit hard with increase in premiums. But the one thing Debbie said that's really important is insurance is mandatory for condo corporations. You can't opt out of it regardless of the cost. All right, so moving on to the next topic, which I'm going to cover, is enforcement. So condos are communities, and like all communities, sometimes people get along and sometimes people don't. Some people follow the rules, some people don't. And so there are mechanisms in place for condo corporations to basically enforce the rules, which we'll find in our declarations and our rules themselves. And depending on what the breach is, what somebody's not following, will depend on where you go for enforcement. But before you take any steps for enforcement, if you're a condo corporation, or if you're an owner who's in a situation where you may have breached a rule, and you may not even have known that you've done that, the major and most important thing is communication. And so it's really, really important that condo boards, property managers working for condo boards communicate with owners, because a lot of times owners don't know what they bought. They don't know the rules, although they should, and they should be reading the documents when they buy their condo. The reality is, and we know that most people don't. And so the very first line of defense when it comes to enforcement is to send a friendly letter reminding the person who's offending the rule what the rule is and what they need to do to correct it. And a lot of times condos will do the 3-strike rule. They'll give 3 warnings before they send it off to legal to take legal action. Now, if communication is not going to work and you have an owner who continues to defy the rules, there's a couple options available. You can go to mediation and arbitration. Sometimes you are required to go to mediation and arbitration. Under the Act, Section 132 has a requirement for mandatory mediation and arbitration. Some things will go directly to court. But nowadays, fewer and fewer things are going to court because we have the Condominium Authority Tribunal, which is called CAT. And a lot of disputes are going to CAT now. And CAT has just recently expanded its jurisdiction as of January this year to include records requests. So if there's any disputes about records, which is what Ashley talked about, if an owner's requesting records and they don't get them, if there's a dispute about if a record has to be produced, that goes to CAT. If there are any breaches of rules or disputes with respect to pets, parking, storage, vehicles, those now also go to CAT. And those are, very common types of breaches that condos have to deal with. And then as of January, if there are any issues that are nuisance related issues, those are now going to CAT as well. CAT also deals with the chargebacks that can occur in relation to any of these issues that they have jurisdiction over, and they can also enforce settlement agreements. So there was a comment in one of the questions before about CAT not being able to enforce its own orders. They can enforce its own orders, and they can enforce settlement agreements as well. Sometimes you will have to go to court to enforce the CAT order. It just depends on how that order came about, whether it's a result of a settlement agreement or not. So at the end of the day, when it comes to enforcement, it's not as easy as it used to be in terms of where you go to enforce. It really depends on what the subject matter of the breach is, and that will dictate where you go. If you are looking to enforce, you're going to need to get some legal advice. But again, the very first thing is start off with communication and making sure that people are aware of what the rules are. And another great way to do this is in your newsletters that go out every month or every 3 months, is just remind people of what the rules are. And education and communication are a great way to avoid having to enforce in the first place. All right. And our last topic for tonight is Ashley Winberg is going to be talking about other laws that apply to condos. I talked about the Condo Act, but there's a variety of other pieces of legislation that also apply to condos. So Ashley, can you tell us about that?
I see a lot of questions about service animals, emotional to pet animals, and comfort dogs, and that ties into the Human Rights Code, which is one of the other laws that apply to condominiums. So condos employees, residents, they have the right not to be discriminated either in their employment or through the provision of housing or services. So it's a condo's rules or declaration may contain a provision that, if applied to someone potentially as a result of a disability, would be discriminatory, such that the corporation may have a duty to accommodate them up until the point of undue hardship. And I'm sure we'll get a couple questions about that in the question section. Another law is the Occupiers Liability Act, because under the condo, corporations are the occupiers of their common elements. So they do have a duty to take reasonable care and protect persons on the common elements from foreseeable harm. Otherwise, they could be held liable. In addition to the Occupiers Liability Act, there's the Occupational Health and Safety Act. This is one that's received a lot of attention recently because, unfortunately, it's been a tough year for everyone. And it's been a very tough year for managers, as John mentioned. Really, managers are deemed to be workers for a condominium corporation. So condominium corporations have an obligation to protect employees, workers, anyone who's conducting work on their site from incidents of workplace violence and harassment. So that's a very hot topic at the moment. There's also the Employment Standards Act and the Labor Relations Act, which apply to any condominiums who are direct employers of potentially cleaning staff, their superintendent. And the Labor Relations Act applies because a number of cleaning companies and staff and security companies are now unionized. So that that applies to condominiums if their site is now unionized. And then there's also the Personal Information Protection and Electronic Documents Act, so privacy legislation that doesn't strictly apply to condos, but definitely should be used by condos to create a set of information management and privacy policies. So an example of where all of these different laws come into play in conjunction with the Condo Act has a lot to do right now with the hot issue of vaccinations and whether or not condos should be asking their residents, employees to be vaccinated. So if you type in my name and the word vaccination in Google, you'll see an article I wrote that discusses how they all intersect in a bit more detail. But because all of these different laws do apply to condos, it is advisable that condos have policies, which as Sonja talked about, are also a hot issue right now, which is internal governing policies, particularly with respect to information management and privacy, human rights, and communication policy. And now some condos, as I mentioned, are also doing vaccination policies and another policy for workplace violence and harassment. So I'll leave it there. I think we'll get a couple more questions about the Human Rights Code in the question section.
And Ashley, you are right. There are tons of questions about that. And maybe we'll just start with that because it's important to understand that requests for accommodation are very complicated matters. They have to be handled carefully because there's not only the substantive right and duty to accommodate under the Human Rights Code, there's also procedural duties. And if you don't handle the procedural duties properly, you can get yourself in trouble. So it's important that you get proper advice on how to handle these matters. But it's also important for condo corporations to know that just because someone makes a request for accommodation, that doesn't mean that that request is going to be granted. The corporation has to do a proper investigation to determine what the disability-related needs are before they make any decisions about accommodation. And the other important thing to remember is that it's needs that are accommodated, not preferences. So somebody may want a certain thing to happen, but you have to determine what the disability-related need is. And maybe what they want is not what they're going to get at the end of the day, because you have to accommodate the need, not the preference. So again, very complicated area. And you got to be really careful how you handle that. Ashley, do you want to add anything to that?
I would definitely reach out. If you receive any requests for accommodation, reach out to a solicitor. There's a lot of different variables that can come into play. So I would definitely reach out to a condominium lawyer that can assist you with that, because it's a difficult area to navigate.
Yeah. And there's some comments about service animals and emotional support animals. There is a difference. A service animal is very specifically defined. Emotional support animals are not service animals. One thing that I run across quite often, I do a lot of work in this area, is it's very easy for people to go online and get one of these cards that look very formal. They've got the Canadian flag on it that identifies a dog as a service dog or a support dog. Those are not regulated, and they are there's no legal requirement for the person that is making an application for one of these cards to even produce any medical information. So do not accept that as satisfactory sort of evidence that somebody needs. Has a medical or a disability related need for a support animal. Anyone can just post a picture on this website, pay the $40 or $50, whatever it is, to get this. So it's very, very important to do the investigation properly to determine whether there is a disability related need, what that is, and then how you can accommodate it, because there is a requirement to accommodate disability related needs.
And on that note, the accommodation process is a shared process. So the individual requesting accommodation has to, comply and provide the corporation in a timely manner with documentation or information requested. And if someone, doesn't engage in the accommodation process and cooperatively disclose any documents or information required, they will not be entitled to the accommodation requested.
Yeah.
And also accommodation also, it's not, I specifically want this. It's sort of a meeting at the minds, assessing the individual's disability related needs.
Yeah, that's so true. And if anybody wants to read a case about what Ashley just talked about, I did a case about 5-6 years ago, SCC 89 versus Dominelli. You can search for it online. And that's exactly what the court said, is that the person requesting accommodation didn't participate in the process. Therefore, there was no need to accommodate. So it is a very process-driven area of the law. Get some advice to make sure that you're not falling into some mind traps. All right, let's move on to some other questions. Again, if you have a question you want to ask live, raise your hand. We'll try and get to you. But the next question is, are board meetings open to owners to attend? And they're not talking about the AGM. The AGM is not a board meeting. The AGM is an owners meeting. So the question is, are board meetings open to owners to attend? Who wants to tackle that?
I'll chime in.
Okay, go ahead, Jeff. Thanks.
Generally not. Sometimes owners or a committee of owners that might be serving at the board, whether it's a recreation or events committee or landscaping committee, etc., might be invited to attend as a guest to a portion of a board meeting. There are portions of board meetings that especially if there's discussion about unit arrears or other things that would be considered confidential and not normally for community-wide consumption. But if there's enough owners that are interested, consider having frequent or maybe twice a year town hall type meetings, quick jump on Zoom, turn it into a happy hour or something like that, or make it fun and engage the owners is a much better way than trying to slot them into a board meeting that's usually packed agenda and privacy and the affairs of other unit owners has to be protected as well.
Anyone else want to chime in?
Yeah, I'll hop in on that one briefly. I've seen this work well and I've seen it work poorly, but I think as a board, if you're going to allow owners to come to a board meeting, I mean, you want to know what they're going to talk about. You want a submission of what they're going to speak about before the meeting so that the directors can discuss it. You don't want to make decisions in front of the owner while they're at the meeting. And you want to generally, if you've got a manager, probably discourage having that direct connection so that the manager can be the buffer for you, because things can slide out of a board meeting format pretty quickly if you have an upset owner. And really at board meetings, you've got so much work to do. I've seen it go well, I've seen it go poorly, but if as a board, you're going to go there, put some parameters around it is really all I could offer.
I think from a legal perspective, no one can attend a board meeting unless they're invited by the board to attend. It's only for board members. So the board has to invite, but there's some practical tips there that Debbie and Jeff shared. And there's a comment about the board of directors has a lot of power. They do have a lot of power. They also have a lot of work. Remember, these board members are owners and volunteers. And for most of the part, none of them are getting paid to do this. But also remember, the board has been elected by the owners to exercise those powers. So they're put in place by the owners to carry out that job. All right, so I see 2 hands raised. We have 2 minutes left. So Pat, go ahead. If you could just get to your question quickly so that we can try and also get Phyllis's question in, that would be great. Pat? Oh, I lost.
There you go.
Okay, go ahead.
At the end of our AGM in 2018, there was a reminder that any homeowner, could have the first 15 minutes of any board meeting to present anything they wish. So meaning they could go to the first 15 minutes, say what they wanted, and then leave. So I availed myself of that one time, and now they don't do that anymore. They don't mention if anybody can go anymore. I'm just saying that's the way our board did it.
Yeah.
They gave an invite and then they took it away. Well, they didn't take it away, they just ignored it from then on. I'm just passing that on. Thank you.
All right. Phyllis, go ahead.
Yeah, when we were talking earlier about registering a lien, I wondered how much that costs, because sometimes you get, people who renege on their mortgage or their maintenance every month. It gets costly. So I just wondered what the cost was to register a lien.
Ashley, do you want to talk about that? Sort of general costs?
General costs, it's not the actual cost registration itself. It's usually a lot of you have the arrears that have accumulated, interest, costs of various legal correspondence. So, it could cost, if once it has to be discharged, at a minimum, potentially like $2,000. It depends. The costs escalate the second things are not paid and interest accrues.
That's a lot of money.
It is, unfortunately. But it's not the actual disbursements for the registration of discharging the lien itself and registering it. It's a lot of the other things that go into it, unfortunately.
Yeah. And
So
there's
sorry.
Go ahead, Phyllis.
So if you get somebody who's constantly in arrears, how do you get them out when they're an owner?
You can't get an owner out for arrears, but you can lien the unit. And if the lien doesn't get paid, you can go and proceed with power of sale, which would then force the sale of the unit.
That's good. That's good to know. So you can do that the first time you have to put a lien on.
Yeah, and you need to remember that there are time requirements to have a valid lien. So that lien needs to get placed within 90 days of the arrears. So you've got to act quickly, and there's different stages in the lien process as well. So if you're looking at collecting arrears, you will want to talk to a lawyer about how you go about liening and what steps you need to take. All right. Well, that wraps up the webinar for tonight. Thank you, everyone, for joining us. Thank you to all of our speakers for taking the time tonight to educate us on what condos are all about. Also, want to take this opportunity to once again thank our sponsors. Thank you to Aaliyah Associates, Condominium Lawyers, Common Ground, Condo Law, McIntosh Perry, Brown and Beatty, and Registon Building Restoration. Once again, without the support of our sponsors, we can't offer these webinars to you free of charge. So please show some love to our sponsors. Feel free to reach out to them and thank them for supporting the CCI Huronia webinars, but also find out more information about the services they provide and their contact information by clicking on their logo, which you'll find on the landing page of our website, ccihuronia.com, or on the events page for this particular webinar. Also, just want to take this opportunity to remind everyone about upcoming events at CCI Huronia. Don't forget, we have the Intensive Directors course on April 22nd and 23rd. Information about that course and to register online, just go to our website, ccihuronia.com. We have a Lunch and Learn webinar on February 24th talking about tenants in condos. And then we also have dates marked for upcoming Lunch and Learn webinars, March 24th, May 12th, and June 6th. So mark those dates in your calendars. The Lunch and Learn webinars always start at 12 o'clock. They go to 1 o'clock. And you do need to register for each webinar individually. So be sure to go to our website, register online. We are going to be talking in our upcoming webinars from March to June about short-term rentals, insurance, and nuisances. So all very hot topics in condo land You don't want to miss any of those webinars. If you have a suggestion for a future webinar topic or a speaker that you would like to hear from, send us an email to admin@ccihuronia.com with your suggestions, and we'll try to incorporate them into future webinars. I also want to just remind people that besides CCI Huronia, there are many chapters across the country that are also hosting in-person and webinar type seminars. If you go to our national website, cci.ca, and look at the bottom right-hand corner, you'll see a calendar of upcoming events of all the events across the country at our various CCI chapters. So be sure to check those out and register for one of those webinars that one of our sister chapters are hosting. So that takes us to the end of today's webinar. This webinar is being recorded. It will be put on the website shortly. So if you want to watch it again, feel free to do so. If you want to share it with someone else, we would love you to do that. But until next time, I'm Sonja Hodis, and from the entire family at CCI to you, we wish you a great evening. We hope to see you at one of our upcoming events, especially the next one on February 24th. And don't forget that CCI is your condo connection. Good night, everyone.